My Lords, with permission, I would like to repeat a statement made earlier by my Right Honourable friend, the Lord Chancellor and Secretary of State for Justice, in the other place. With permission, Mr. Speaker, and further to the written ministerial statement I laid in the House earlier today, I would like to make a statement. Last autumn, the Government launched 2 consultations on far-reaching plans to reform punishment, rehabilitation and sentencing of offenders, and legal aid in England and Wales, respectively. Today, I have laid before Parliament the Government's response to these consultations. I am also introducing the Legal Aid, Sentencing and Punishment of Offenders Bill to give effect to those measures we are taking forward that require primary legislation. Mr. Speaker, protecting the public from crime and punishing lawbreakers are the most fundamental responsibilities of the state towards its citizen. But the sad truth is that after 13 years of government, over 20 criminal justice bills and more than 3,000 new criminal offences and an explosion in the prison population, Labour left the system in crisis. Most of our prisoners spend their time behind bars, idling in their cells with ready access to drugs. A bigger scandal still is our reoffending rate, which are straightforwardly dreadful. Within a year of leaving jail, half of offenders will have been reconvicted of further offences. The same people cycle round the system endlessly, committing more crimes against more victims. The best way to reduce crime is to reduce reoffending, and that remains the central feature of our programme of radical reform. Prisons must be places of both punishment and reform. Today I can confirm that we plan to deliver a full working week across the prison estate. We will legislate to extend powers to use money earned by prisoners to support the victims. We have never proposed that community sentences should replace prison sentences, but we will introduce tougher, properly enforced community punishments where offenders work longer hours unpaid, at least 4 days a week. Drug abuse lies behind much, if not most, criminality in this country. It is not acceptable that drugs are too readily available in prison. We are taking forward plans to reduce addiction across the prison estate, improving security and introducing drug-free wings in jails. We must tackle other root causes of criminality, particularly alcohol addiction, mental illness and lack of skills. But we will ensure that we only put taxpayers' money into those rehabilitation programmes that actually work. Public confidence in the criminal justice system is unacceptably low. That is why we want to take forward plans for a new offence with a mandatory minimum sentence, a prison sentence of 6 months for adults who use a knife to threaten and endanger. We will also consult on proposals to criminalise squatting, and we will bring forward legislation to clarify the law on self-defence. In addition, I can confirm our intention to improve the use of remand and reduce the number of foreign national prisoners in our jails. Discount for early guilty pleas have been part of the criminal justice system for decades, and for good reason. Personally, I was particularly impressed by the representations of the senior judiciary and other criminal justice experts who said that increasing the maximum discount on offer for an early guilty plea at the earliest possible stage might result in the sentence served being too short in some serious cases. I considered addressing that problem by introducing a greater degree of judicial discretion, but we could not make that work. We have decided, therefore, to retain the present system. The consultation also produced a strong opposition to the indeterminate sentencing framework. This was introduced by the last government and sold as a way of protecting the public from a small number of the most dangerous offenders. But it has never worked as Parliament intended. It has created a flawed system where thousands of offenders have already served their normal sentence or tariff but no one can predict when or if they might ever be released. That is why, as the Prime Minister confirmed earlier today, we are reviewing indeterminate sentences of imprisonment for public protection, with a view to replacing them with a more sensible, tough system of long determinate sentences. This will see judges handing down life sentences in a greater number of very serious cases, including mandatory life sentences for the most serious of repeat offenders. Serious sexual and violent offenders will spend at least 2/3 of their present sentence in prison, rather than being released halfway through. We intend to return to the best aspects of the system before IPPs were introduced. Turning to legal aid reform, we have much the most expensive system in the world, except for Northern Ireland. There it costs £39 per head of the population, compared with £8 per head in New Zealand, a country with broad similar legal system. I think I better correct that. I think ours is £39 per head of the population, compared with £8 per head of New Zealand. The last government consulted on this subject more than 30 times since 2006, and still left us with the mess we now have to tackle. In some cases, the system encourages people to bring issues before the court, where other solutions might be better. In others, it enables people to pursue litigation that they would not contemplate were they paying it from their own pocket. Following careful consideration of more than 5,000 responses, I am bringing forward proposals which I believe will ensure to public funding in those cases where most require it, encourage early resolution of disputes instead of unnecessary conflict, and ensure much better value for money for the taxpayer. I can announce that we will retain legal aid in cases where people's life or liberty is at stake, where they are at risk of serious physical harm or immediate loss of their home, or where their children may be taken into care. In response to consultation, this will include strengthened provisions for victims of domestic violence and for children at risk of abuse or abduction, and the retention of legal aid for special educational needs cases. Legal aid will no longer be routinely available for most private family law cases, clinical negligence, employment, immigration, some debt and housing issues, some education cases and welfare benefits. It will also no longer be available for squatters resisting eviction. We have also decided not to abolish the current capital disregards for pensioners and for equity in the main home in assessing an applicant's eligibility for legal aid. We will not introduce a £100 contribution for capital for those assessed at having £1,000 of disposable capital. Mr. Speaker, what all this amounts to is a balanced and sensible package of reform of the kind the government was determined to achieve when we published our proposals. Our plans mean a return to common sense in the justice system. On legal aid, the overall effect will be to achieve significant savings while protecting fundamental rights of access to justice. On sentencing, we will be delivering punishment, protection, and a renewed focus on breaking the cycle of crime and reoffending.
My Lords, can I begin by thanking the Noble Lord the Minister for repeating the statement and for advance sight of the statement that he has just repeated. My Lords, our justice policy should of course be about protecting the public, punishing and reforming offenders, being on the side of the victim and bringing crime down. And that underpinned our record in government, which led to a 43% fall in crime, reductions in reoffending and serious improvements in youth offending rates. My Lord, some crisis. But this government demonstrates it's not that what matters in their approach to crime and justice. What matters is cutting costs, despite the impact it could have and is likely to have on our communities. We think the government are right to have seen sense and taken heed of opposition to cost-driven proposals to reduce sentences by 50% on early guilty pleas. A powerful coalition of the judiciary, of justice groups, the Sentencing Council and victims groups themselves rightly questioned the motivation and effectiveness of that particular policy. But let's be clear, the policy had been agreed by Cabinet. It's no good now, Number 10 distancing itself from it. Perhaps the Noble Lord the Minister can answer these questions. Firstly, can he outline why the Prime Minister ditched this proposal when the government was so wedded to it just a matter of weeks ago? Secondly, why the decision was taken to change the name of the bill from the Legal Aid and Sentencing Bill, as it was called until late last night, to the Legal Aid, Sentencing and Punishment of Offenders Bill. What is the hope in tinkering with the words meant to achieve? Perhaps the Noble Lord will answer that. We know, of course, from impact assessment provided with the Green Paper that removing the option of remanding offenders in custody for certain cases would save £50 million and 1,300 prison places. Does this proposal still remain, and in what form? On IPPs, how will the government ensure the safety of our communities when considering which offenders ought to be released? Once again, the impact assessment tells us that financial savings doing this will be sizable. Obviously, the focus is on saving money. Today, we find that the Noble Lord is to undertake an urgent review of IPPs with a view to replacing them. Why, over the last 13 months, when there's already been a Green Paper and consultation, why is there need for another review? How does he reconcile losing thousands of frontline probation, experienced prison and probation staff, with the government's obvious desire to see, firstly, an increased number of offenders diverted into specialist drug, alcohol and mental health facilities, and secondly, more prisoners working who will clearly need more supervision? How do they fit together, those policies? This morning, in his press conference, the Prime Minister said savings would have been made by the 50% proposals will be found elsewhere in the Ministry of Justice budget. Can I ask the Noble Lord the Minister to explain to the House exactly where these savings will be found and when? Can I turn to legal aid cuts? Perhaps the proposals that were mooted in the Green Paper have been heavily criticised across the board. Not because there is no room for legal aid cuts. We've certainly put up alternative proposals, as have the Law Society and others do. The reason they've been criticised is because of the attack on social welfare law. Does he agree, does the Noble Lord the Minister agree, that these proposals, if implemented in legislation, will decimate social welfare law, making it impossible for the most vulnerable to get legal help for legal problems, including welfare benefits, debt, employment, and all but the most extreme of housing cases? Does he agree that evidence shows that exactly this type of legal help that is given through legal aid now, given early, can and does often solve the problems involved and thus save the state when things otherwise descend downhill? Does he agree with the CAB, who say that £1 spent on welfare benefits advice saves £8.80 in future spending, and that every bit of housing advice saves for £1 legal aid saves £2.34p, and every bit of debt advice saves £2.98p? How can this policy possibly save public money? More importantly than even the financial side of it, how does he argue that the removal from access to justice, because that's what it is, for some of our most vulnerable fellow citizens is justified. How will these people be able to receive legal advice? Who will it come from? How will their legal problems be resolved? My Lords, they are effectively excluded from access to justice, and this will be deliberate government action. And why? The amount of money saved overall will be less than nothing. Many CABs, many law centres and many high street practices who do a fantastic job for comparatively little reward compared to other fields of law, looking after the poor and marginalised, will have to close. The noble and learned Lord Bingham wrote in his book The Rule of Law last year that the denial of legal protection to the poor litigant who cannot afford to pay is one enemy of the rule of law. Yet this is exactly what the government intends to do. This House, and around the House too, has always seen itself as one of its roles to look after the vulnerable, the marginalised in our society. And when this bill comes from another place, I'm sure this House will continue to do its duty as far as that is concerned. My Lords, these proposals are not only financially illiterate, they are, and I choose my words carefully, morally outrageous. I wonder how the noble Lord, with his great tradition as a liberal and as a man who is a great supporter of social justice, can give his support to these proposals.
My Lords, I thank the noble Lord for his response, and I will try and deal with the issues that he raised. I suppose the first point to make is that moral outrage butters no parsnips. The issue that the Ministry of Justice was faced with, as was the government, was that we were spending beyond our means. We had to accept, as part of the spending review necessary to repair this country's economy, there's a groan across the board. It is no use opposition members pretending that if they had won the election, they would not have had to come into office and face some of the realities that we have faced, including having to make cuts in areas which in normal times we would all be find it we can all enjoy office in good times. It's in difficult times that the necessary decisions, the hard decisions, have to be made in government. And we were faced with cutting our expenditure from 10 billion to 8 billion. And as noble Lords opposite will know very well, this is a department that really only has 4 big tickets. It spends on prisons, it spends on probation, it spends on legal aid, and it spends on staff and court services. And each of them have had to take some very difficult hits. To take the points that made, as both my noble friend, my right honourable friend, the Prime Minister, and the Lord Chancellor made clear, the decision on the 50% discount change was as a result of consultation and discussion within government, something that is very common in coming to a final decision. As was indicated, quite a weight of opinion from the judiciary that, as the Lord Chancellor made very clear in his statement, that this was a bridge too far as discounts are concerned, despite some attractive possible savings and from some impact. I mean, I think it is the truth that early pleas do have a beneficial effect on victims. In some victims that are spared the trauma of going through a trial. But I think also the weight of advice that such a discount offered to certain offenders would be unacceptable to the public and to the judiciary, and we listened and we changed the proposal that was in the Green Paper. I've got to say that's what Green Papers are for. I'm old enough to remember Harold Wilson introducing Green Papers to allow a period of more flexible discussion than White Papers provided. So that's the background. On the change of name to add punishment of offenders, it is partly a presentational matter, but it's one that I don't think we should ignore. That I'm very eager that we win the discussion in this country about prison reform and rehabilitation of offenders. But we're not going to win that debate if the public at large believe that the proposals that we're putting forward leaves out punishment of offenders, leaves out concern for victims, and therefore presentationally the added words we hope will reassure the public that whilst a large amount of both the Green Paper's thrust and this bill's thrust is to examine ways to get into that cycle of reoffending, both to save the costs of reoffending and save the trauma of what reoffending does to future victims. We need public opinion to help us and support us in that task, and in that we have to reassure them that we do not forget the element of punishment in the approach to crime. On the question of our remand proposals, they remain in place and will be taken forward. The policy is to restrict the availability of custodial remand in cases where it is apparent that there is no real prospect of the defendant being sentenced to imprisonment if convicted. On the IPP, it was again a product of the consultation. Just as a lot of the feedback on the Green Paper was against the 50% discount, again, a lot of the evidence from the judiciary was that IPPs didn't work. They build up problems. They left doubt and uncertainty in the system. And we have listened. We are going to consult and bring forward proposals by the autumn to replace the present regime. The Noble Lord mentioned the fact that the prison service and the probation service are going to be put under pressure by these cuts and by further demands made on them. Well, I think that's true. I mean, the whole strategy, the thrust of the Green Paper and now this legislation is to try and get more for less. And there are some indications that we are not being over-optimistic in that. We are challenging both the prison service and the probation service to look at their own efficiencies in the way they carry out their role. And we have a wide range of proposals right through the criminal justice system to bring in both the private sector and the voluntary sector to partake and participate in payment by results pilots to see if there are alternative ways of delivering the service of both of custody and post-custody treatment. But this will also be part of a more general approach to try and get a more holistic treatment of people whilst they're in custody and post-custody. I understand what the Noble Lord said about social welfare. It is an extremely sensitive subject. It is, and again, I've answered questions before, you cannot have a system that is supposed to be targeted at the most disadvantaged in our society, cut the budget to that programme, and not, by implication, be causing problems for those who are so disadvantaged. The government is not abolishing funding for social welfare law. About 50 million will be spent in this area, and not all social welfare law cases will be outside scope, but neither are they all of equal importance. We are trying to make sure that where we retain the social welfare programme, we will keep two areas where there is real problem in debt, in housing, in community care. We have subjected them to analysis. In developing our proposals, we have taken into account the importance of the issues at stake, the individual's ability to present their own case, including their vulnerability, the availability of alternative sources of funding, and the availability of alternative routes to the resolving of this issue. We must face up to the tough choices, but this has allowed us to focus resources to those who need it most in the serious cases where legal advice and representation is justified. We are still keeping funding for mediation services, and we are trying to make sure that that funding is kept in the most vulnerable of cases. We are also looking hard at whether we can help in those cases of advice which the Noble Lord quite rightly declared importance in this area. It is not, when delivering a programme like this, and we are talking about legal aid, an easy case to make, but it is a case against genuine economic reality. One, I suspect, ministers would have faced from the opposition if they'd have faced this dispatch box. And I certainly have no problem in arguing the moral case that we have made the tough decisions that are needed in government, and we've made them to try and keep faith with the most vulnerable in our society.
May I congratulate my noble friend? May I congratulate my noble friend on the review of indeterminate sentencing? That is an injustice which has been perpetrated over a number of years. There are many people who are suffering as a result of those sentences being passed upon them. And I would ask my noble friend whether there are any proposals for dealing with those who are currently serving indeterminate sentences and cannot get their freedom, though the tariff period has elapsed, because they can't get access to courses. My Lords, may I also applaud the abandonment of the proposed 50% reduction, automatic reduction on guilty pleas. I've always opposed the concept that this government, or any government, should say what a proper sentence should be, or things can vary enormously from where there's an overwhelming case and a person must plead to those where there is a very little case. And his plea of guilty does indicate remorse. A judge is in a position to judge that at the time. And can I ask my noble friend if the government intend that judges should continue to exercise such a discretion? On the other hand, I'm dismayed at seeing the mention of mandatory life sentences. They exist only for murder. Is it proposed that mandatory life sentences should be imposed for anything other than murder? That would be a very strange thing to happen. Lords, on the question of legal aid, clinical negligence is to be out of scope. Surely the government will permit the granting of legal aid for the investigation of clinical negligence, which is hugely expensive and beyond the means of anybody, particularly where children are involved. And surely justice demands that clinical negligence be properly supported to that degree. And finally, in family law, has the government considered the importance of family solicitors in reconciling parties and dealing with issues such as custody and maintenance, and the enormous amount of money they save from having these disputes settled out of court?
My Lords, right, I better get it right on intermediate. Not that. Oh, yes. It's amazing what help comes from the box occasionally. On the question of indeterminate sentencing, what has been committed to today is a review. That review will, we hope, be concluded by the autumn, and we will then bring forward proposals on what happens next. On the question of what we're doing with the people already on IPPs, each individual prisoner will continue to be assessed on a case-by-case basis by the parole board. The review will look at all the ways these assessments operate to ensure that the real work is done to reform offenders when in prison. I think when my noble friend sees the full proposals, he will also see that we are taking a lot more care to try and address the issue of rehabilitation of these long-term offenders whilst they're in prison. I take the point about judges' discretion. The longer I've been in this job, the more convinced I have been that we should rely on the discretion of a well-informed judge rather than Parliament trying to second-guess the judiciary at long distance by too restrictive legislation. But we will see how this unfolds. Because one of the issues that is certainly being brought forward is the idea of mandatory life sentences for serious repeat offenders. I've got to point out that this is in a bill which is going to go through both houses, so I'm quite sure that I will hear more of that of the argument my noble friend deployed when the bill comes before this House later in the year. On clinical negligence, currently legal aid is available to those who qualify financially and who have suffered negligent medical treatment to seek damages against any type of public or private medical practitioner. Whilst these claims for money compensation, we consider they often raise very serious issues, especially where the damages are required to meet future needs, and some litigants will be vulnerable because of disabilities resulting from the negligent treatment. However, although the issues raised are likely to be very important, we consider that there is a viable source of alternative funding to legal aid in CFAs, which are more readily available in such cases than for other claims. We therefore consider that legal aid is not justified in these cases and that our limited funding would be better targeted on other priority areas. I take the point which he makes about solicitors. One of the good things about solicitors is that they are increasingly branching out into offering mediation services, something that we very much support.
My Lords, I too welcome the review on indeterminate sentences for the protection of the public, introduced by the previous administration in 2003. Since the opposition to IPPs is so strong on all sides, including, if I understood the Noble Lord correctly, opposition among the judges, I, like the Noble Lord, Lord Berg, wonder why a review is necessary. Why can we not simply repeal the relevant statute and leave it at that, the relevant section in the 2003 Act? And secondly, I do not like, as the Noble Lord knows, mandatory sentences. I do not like mandatory sentence for the use of a knife to threaten or endanger. Is there any evidence at all that the sentences currently being imposed by the judges in those cases is too low? If not, why do we need a mandatory sentence? And thirdly and lastly, the most noticeable absentee from the statement is anything about Schedule 21, which imposes on judges a rigid framework in murder cases. There was a great deal of opposition to that too, and yet there's nothing about it at all in this statement. Once again, why do we not leave it to the judges who handle these cases to impose the appropriate sentence, advised as they are by the Sentencing Advisory Commission created for that very purpose?
My Lord, even as I was saying the words about the decision on mandatory sentencing, I had the noble and learned Lord very much in mind, and I know his views on this matter. I think we will just have to see how this goes through, because I do know that, that there are conflicting opinions on this, and as I said before, my own inclination is to see a lot more judge power employed in these, rather than getting ourselves into positions where we might find the prison population surging, not because of some surge in crime, but because we find that some of the changes have simply snared in people who might not otherwise have been sent to prison. On the Schedule 21, we want a simpler and more transparent sentencing framework that is also more coherent. As a possible simplification of the sentencing framework, rather than a measure to change sentencing practice, we consulted on a proposal to reform Schedule 21, which sets out the starting point for determining the minimum terms to be served by an offender receiving a mandatory life sentence for murder. There was some support for revisiting the drafting of these provisions, but others took the view that the courts have already interpreted them in a consistent and flexible way. We have therefore concluded that reform is unnecessary at the present time.
Lords, how many of the civil legal aid, how many of the estimated 700,000 cases for which entitlement would have been lost under the original proposals will now be retained, and what will be the estimated cost of those changes to restore legal aid and advice which would otherwise have been removed? And second, would the Noble Minister tell us whether it's correct that 90% of the 5,000 responses disagreed with the proposals in relation to legal aid.
I'm not sure what the statistics are on responses. If you were about to cut a budget and you ask for opinions, I would guess you're more likely to get more people objecting to the cuts than you are to being in favour. But that doesn't take away the validity. We did get a very large number of responses, and a large number pointed out that various impacts, like the point that was made by my noble friend Lord Thomas, that sometimes the solicitors on legal aid perform early advice that saves problems further down. It's a difficult one to balance. I've never tried to mislead the House that, in part, the things that we have done have been done for cost reasons because of the constraints, and that means that some of the decisions have been hard decisions. But the estimate is that we will reduce cases by some 500,000. Something like 600,000 cases will will be removed from scope. It is, on the social welfare end, an extremely severe cut. And part of the debates we will be having will be whether the arguments that we are making, that in this area we have got into a situation where there has been too much publicly funded litigation, where there is scope for much more scope for mediation, much more scope for non-legal advice. Those are the kind of things that will be tested as this bill goes through the other place and through this place when it arrives.
My Lords. Thank you very much. My Lords, the statement refers with approval to some judicial consultation which has already taken place. Can my noble friend tell us whether judicial consultation has yet extended to the plan for a mandatory sentence for life crime? And if so, can he tell us what was the character of the judicial response?
That it. I do know that my Right Honourable friend, the Lord Chancellor, has very regular meetings with the Lord Chief Justice and other senior judiciary. Those meetings are private. He certainly hasn't made me aware of whether he's actually discussed these proposals with the Lord Chief Justice or with the judiciary in any other aspect. If he has, I will respond in writing to my Right Honourable and my noble and learned friend. But I'm not aware of a formal consultation. But if one has taken place, I will make him aware of it.
Mediation fails. Sorry, when mediation fails, as it sometimes can, and there's plenty of room for obstruction as far as that is concerned, does the Right Honourable Lord envisage that there would be a remedy available for a person who is prejudiced by that sort of position?
It is extremely difficult if you're saying that you're going to push towards mediation as you say, if somebody refuses to take mediation or to tries to sabotage mediation, that will cause problems. Whether that would be sufficient to enable the injured party then to get legal aid, if it is outside scope, I suspect not. But again, I will take clarification on that, and if I'm wrong, I will write to the noble lord. In any event, but my feeling is that except in exceptional circumstances, the mediation would be the end of the road unless people were to take other means of financing their litigation, but not legal aid.
My Lords, crossbenchers have just been. Can I declare an interest as someone who's been in the solicitor's branch of the profession for over 50 years, and also admit to having had a passion for legal aid the whole of that time, because will my noble friend not agree that legal aid has been the one thing that has stood between a citizen and getting some sort of equality before the law, and that the severe cuts to the scheme that are announced today, although long foreshadowed, will inevitably strike at the heart of access to justice. And would my noble friend also agree that one of the reasons that makes this country more dependent upon legal aid than perhaps any on this earth is that we legislate, my lords, at a greater rate than any democracy I've yet been able to discover, and I've done some research on this. The torrent of law that we pour forth from this Parliament is of itself a great creator of legal need amongst the whole society, poor people no less than rich. And is it not a sort of organised hypocrisy for us to go on doing as we do and at the same time cut the wherewithal for the citizen to have access to desperately needed advice and assistance? And lastly, and practically, could I just ask my noble friend if he would please have particular regard for the needs of the Citizens Advice Bureau, of which there are over 1,000 in this country. The bulk of their effort is voluntary, and to sustain them with government assistance will yield a better return on scarce money than perhaps anything else.
On the wider point my noble friend makes about the amount of legislation, I think that's probably for another debate. We're not abolishing legal aid, but we are making cuts on the civil legal aid side. We will abolish the Legal Services Commission and vest responsibility for the administration of legal aid with the Lord Chancellor. We will, as I've said, implement reforms to the scope of civil legal aid services, enable the courts in ancillary relief cases to make interim lump sum payments against a party with means to pay other parties' costs, facilitate the creation of a supplementary legal aid scheme by enabling a percentage of a litigant's damages to be paid back into the legal aid fund to support the funding of future cases. And we will implement Lord Justice Jackson's reforms to the costs of civil litigation, abolish recoverability of success fees and after the offence insurance premiums from the losing party, and amend the Prosecution of Offences Act 1985 to cap payments made to acquitted defendants from central funds. We are reforming legal aid, we are targeting legal aid, but we are not abolishing legal aid, because I share my noble friend's concerns for its importance in our system and in the citizens' access to justice.
No order.